Thank you very much for joining me for our webinar today on Kingdom of Saudi Arabia construction in USA, useful tips to know. In the seminar today, I'll be presenting. I'm a partner in the Beale Dubai office with Jeremy Russell, associate in the Dubai office, to give an overview of things to consider when contracting in the UAE. Jeremy will be taking you through some issues to consider when contracting in the public sector. Then I'll be going through some issues for contracting in the private sector. This is a big topic, so there's a lot to cover, but we hope to be able to give you some useful highlights that you'll be able to take away with you. So why Saudi? Currently in the GCC, what really is a very challenging market. There has been forecasts of growth of 6 to 10% this year, but it's very doubtful that that will occur, particularly with recent events. Hopefully we'll see an uptake towards the end of the year. There was a recent Mead report which showed that actually new contract awards in the UAE will be at their lowest level since about 2008. However, in the GCC as a whole, contract awards for this year will remain about the same as last year. The reason for that level being maintained is primarily the activity of Saudi Arabia. As we're aware, Saudi Arabia has been diversifying its economy away from oil dependency. There's lots of small projects going on with new cinemas opening up, but there's also a large amount of significant investment being driven and funded through the Public Investment Fund. That was recently topped up by the Saudi Aramco release, which raised about 25.6 billion USD into the coffers for Saudi Arabia. However, then we also have to think about recent events. COVID-19 is certainly impacting the entire region, and travel with Saudi Arabia is being impacted at the moment, so we don't know how long that's going to go on for. And there's also the recent oil price collapse, the trade war between KSA and Russia. I think it was a 25% drop yesterday in oil prices, so we'll have to see how that will impact the government's ability to fund projects in the longer term. But there are some significant projects out there, such as King Abdullah Economic City, the King Khalid International Airport Terminal 5, Jeddah Corniche, Riyadh Metro, Red Sea Project, the Qiddiya Entertainment Project, as well as Neon City of the Future. So there is a lot of work being undertaken there. I personally know a lot of professionals and friends who are now moving and looking at Saudi Arabia as a future for the next few years as being the centre of activity, or the main focus of activity in the GCC region. Now I'll hand over to Jeremy, who will be taking you through some issues when contracting in the public sector. Thank you, Jeremy.
Thanks, Scott. So I suppose to start off with contracting with the public sector, we've got to look at firstly the new government tenders and procurement law. So the KSA Finance Ministry announced August last year a new government tenders and procurement law, the GTPL, which will regulate government tenders and procurements moving forward. The reason for the introduction of the new GTPL is to provide greater flexibility in the procurement process. And it also applies to all government entities across the kingdom. So this will include different ministries, departments, public institutions, public bodies, and those with an independent corporate personality. So it's quite a broad set of laws, and it does apply kingdom-wide. A few of the key points in regards to the new GTPL is it's to provide greater flexibility in terms of procurement and to increase economic efficiency. It's also designed to favour local companies, local SMEs, local Saudi listed companies, and they're going to be given priority over foreign companies. And there's a few ways that that's going to be done. One of the ways is that SMEs, local SMEs, are going to be exempted from providing bid bonds. Additionally, there's been the establishment of a local content and government procurement commission. And this was established by way of a separate royal order on the 27th of December 2018. And it specifically focuses on ensuring that Saudi publicly listed firms and SMEs can win contracts, or we're not winning the entire portion of the contract. We're not winning the entire contract, at least winning a portion of those works. And they refer to that as a portion of local content. There's also going to be some favouritism shown to Saudi nationals who own a greater than 50% stake in a company by giving them a 10% price advantage on bidding. And if it's a publicly listed company, that company will receive a 5% price advantage. It's quite significant when considering the advantages that they're going to receive in terms of their work. So, as someone who is looking to bid for that work, it's definitely worth considering how in your submissions you highlight your links with local SMEs, how you highlight in your submissions how different portions of work is going to be attributed as local content, and how you give that local content to SMEs who you share various partnerships with or have strong working relationships with. The GTPL also endeavours to give a wider choice of procurement methods to various government entities. So the Government Tenders and Procurement Law describes 8 different methods of contracting that must be used by various government entities, as compared with the current law, which regulates only 3 methods. So that includes general tenders, closed tenders, and then direct purchases. So really there's now 5 new methods available, and these include multi-phase tenders, framework agreements, electronic reverse auctions, requests for consultancy services, and an RFP model or a competitive negotiations model. Very briefly, the multi-phase tenders approach is where a contractor first offers the technical details of their bid to inform the specifications of the RFP. The contracting party will then decide the required specifications or the specifications which they prefer based on the submissions that they receive, and then an open price-based bidding process will be established at a later stage. Framework agreements. Various framework agreements are going to be developed for specialist types of work, and the implementing regulations, which are yet to be released, will specify which framework agreement will be applicable for what type of work. Request for consultancy services. I mean, this is the standard RFP model. This doesn't change, and this won't change moving forward. So consultants that are operating in the region shouldn't see too much of a difference with the implementation of the new GTPL in terms of the actual mechanism under which they tender for work. But still, they should be alive to the additional requirements that will come about as a result of the GTPL. 2 of the most interesting new procurement methods are arguably the electronic reverse auctions method and the RFP model or the competitive negotiations method. So the electronic reverse auctions method will introduce a reverse e-bidding online platform where bidders will have the opportunity to submit on this online platform their tenders with successfully lower bids during a specified bid period. So clearly this is a mechanism to apply some price pressure to bidders. So as the time expires, expect to see lower bids being submitted by each party trying to win that bid, similar to your eBay auction. In Australia, we call these a Dutch auction, but they go by a few different names. In terms of your strategy while bidding for a project that is tendered using this multi-phase tenders mechanism, it's certainly worth considering at what price you initially you initially enter into that online portal and how you might go about reducing that bid successfully with your successive submissions. So consider absolutely what is your bottom line, and then maybe work up from there, building in additional profit or those risk margins. In terms of the RFP model or the competitive negotiations method, this is going to be used when the end product is unique. So the government agency or the government entity will know what it wants, but the construction methods and the specifications aren't readily available. So this will then allow for prospective contractors to offer different methods and solutions and at various price points for the government agency to then evaluate. While this should not only maximise the cost benefits and the financial modelling for the government agencies for projects where they are unique and where they don't have a set price, or it's difficult to actually price that work, it will also allow the introduction of innovative solutions by bidders. So as a bidder, you will be able to flex your muscle in terms of, what solutions can you offer, at what price point, how can you best meet the design requirements of that government entity. And for larger, more output-focused projects, this will also permit the government to consider not only price, but also the quality and the experience that they will receive from those bidders. So it's certainly worth considering how you bid for that project, and making sure that the government entity is aware that you have a strong record in terms of ongoing outputs and being able to manage those projects to the best of your ability, and you'll be able to offer them a strong service. It's also important to remember that when bidding, the contract value will be inclusive of all taxes. I think Scott's going to briefly touch on withholding taxes, but certainly something you should consider in terms of your company structure when entering the market, how best to structure your entity in order that taxes which will be applied in terms of the contract value are minimised. There's going to be the application of performance bonds on all government contracts, and these performance bonds must be supplied within 15 days in order to secure the award. Performance bonds will also be applicable for consultancy appointments. At the moment, speaking to some clients, we are aware that there is some flexibility in this regard, but we expect that under this new government tenders and procurement law, either an exception from the minister will be required, or at the very least, the starting point will be that the contract will require that a performance bond is provided. There's going to also be the application of a standstill period of 5 days to give parties a chance to object to the award decision if necessary. Now, there's been no specification as to how that challenge procedure would work, and without an understanding of the mechanism behind the challenging of an award, we're unsure as to whether this carries any real teeth and whether it's a mechanism which parties would actually like to rely on. With that said, it's also something that should be considered in light of Saudi having quite a large project pipeline, and whether you want to put yourself in the position of objecting to an award for a reason which might not carry, or under a mechanism which might not carry any teeth down the line. So certainly something to consider. There's also going to be the establishment of what is called the Strategic Procurement Unit. So Article 13 of the new Government Tenders and Procurement Law intends to establish a Strategic Procurement Unit, SPU, which will coordinate the purchase of commonly used goods and services across the various government entities, thereby ensuring that contracts are priced at competitive rates. Additionally, the SPU will be responsible for unifying the technical specifications for commonly used goods and services, and then launching tenders and receiving and reviewing bids to select the best bidder in accordance with those unified tender documents. It will also be required to conclude framework agreements and then prepare model tender documents for those commonly used goods and services. So if there's a government entity that's tendering out a project, we expect that they're going to be required to send any feasibility studies or evaluation studies or any other tender documents to the SPU to review whether they include commonly used goods and services. And if they do, for the SPU to then either give approval to the tender documents as they are received, or then impose amendments on that government entity to ensure consistency across those commonly used goods and services. The draft law isn't very clear as to the role of the SPU, as to whether it's going to be limited to a certain number of commonly used goods and services, or whether its scope of intervention will extend to all government procurement processes where they even very briefly touch on a certain commonly used good or service. So although there are different provisions describing the role of the SPU, they are somewhat conflicting about the role of the SPU. But in our view, the majority of them seem to suggest that the role is going to be non-general and it's going to be limited to certain categories of goods and services. But we fully expect the implementing regulations to clarify this point. Just briefly on those implementing regulations, they were expected to follow some 2 months after the release of the government tenders and procurement law. They haven't yet been released, so we're still awaiting those. It's not particularly uncommon in Saudi Arabia to experience some delay with the follow-up of implementing regulations. Usually we expect to see it anywhere between, them released anywhere between 6 weeks and 3 months. Currently it's been closer to about 6 months now since the release of the actual law, so it's starting to drag on a little bit. But given that it's quite a substantial piece of legislation that will affect the entirety of the kingdom, it's not so surprising that they are taking their time with the release of the regulations. Okay, in terms of default rights, the government has now included a few default positions within the expected framework agreements and contracts, which are things like they will now be allowed to pay subcontractors directly to help overcome project delays. So where they're delayed as a result of a contractor potentially not passing payment through to its key subcontractors, and where that is then leading to a delay, the government has the right to step out and around the contractor to directly pay those subcontractors. There's also now the inclusion of delay penalties, which will be imposed. These are stated to be the following. So if a contractor is late in performing the contract, a delay penalty not exceeding 6% of the value of a supply contract and not exceeding 20% of the value of other contracts shall be imposed. In continuing services contracts, where a contractor fails to duly perform its obligations, a fine not exceeding 20% of the value of the contract shall be imposed, along with the deduction of the value of the unexecuted work. So that's a pretty significant deduction penalty which could potentially be imposed. Throughout the rest of the Middle East and Gulf countries, it's typical to see a 10% cap on any delay damages which might be imposed. But the increase of this to 20% is significant, with then the additional deduction of the value of the unexecuted work being imposed. Additionally, these ratios may also be increased with prior approval of the minister, provided that such increase is communicated to bidders before bids are submitted. So by no way is this uniform across all projects. They could be increased with approval of the minister. So it's certainly something you should pay particular attention to in your bid documents. Additionally, where there have been incessant delays, there are now expanded rights for the government entity to terminate a contract or to partially withdraw works from a contractor, with the option of completing those withdrawn works at the contractor's expense. So a typical change that we see in some of the FIDIC contracts that are used within the Middle East, but this is now being enshrined in the GTPL in Saudi Arabia. So expect to see provisions along these lines included within the draft contracts that you receive. The GTPL will also set out various requirements for contract forms. So this is a move away from the old public works contract, which many people who are operating in Saudi Arabia will have already seen. Again, this provides the government entity with a bit more flexibility. So rather than using the old public works contract as a one-size-fits-all document, there's now going to be a few other framework agreements and contract options which are available. There are, however, some standard rules in terms of these contracts. One of them is that they're to be in Arabic or dual language. Typically, the other language will be in English, but Arabic will be the prevailing language, so that will be used for matters of interpretation and implementation. The implementing regulations will also specify there's certain types of contracts that are going to be used by the government entities for specific works. So expect that where there is or where you specialise in a particular field of works, it's likely that the implementing regulations will specify which framework agreement will be applicable for those specialist works. Additionally, government entities will only need to submit their contracts for approval by the Ministry of Finance if the contract relates to an allocation in the general budget of the state. For example, there's not going to be if there's no separate budget, then ministry approval will not be required. There's also going to be a big push for knowledge transfer. So the GTPL includes new measures which set out knowledge transfer requirements. And these are both practical and theoretical skill transfer requirements. And this is intended to aid government employees in assessing and sharing knowledge and skills. So Article 35 of the new Government Tenders and Procurement Law says the Commission may, under its own volition or at the request of a government entity, subject prior to approval of the Ministry, enter into contracts for the Saudisation of the industry and knowledge transfer according to the rules and procedures stipulated by the regulations. Contracts may include clauses relating to knowledge transfer, training and transfer of operating skills to employees of the government entities. So similar to the local content requirements and the favouritism that's being shown to local entities, there's also going to be a requirement that companies actively engage in the training of their local Saudi staff, as well as the staff of the government entity. As a tenderer, this presents a good opportunity to distinguish your offering from other tenderers. This should be included and specified within your tender as to how you plan to go about meeting these knowledge transfer requirements. The specifications of those requirements we expect to be set out in the implementing regulations. Again, we haven't received those yet, so we don't know how broad they will be. But even where the implementing regulations only might specify a few items, if you are able to demonstrate your capacity, capability and willingness to engage with the training of local Saudis, we think this will definitely provide you with a way of distinguishing your offering, but also showing your commitment to the region and thereby bettering your tender. I've already touched on the standstill period of 5 days in relation to your ability to object to awards. In terms of contract administration, there's going to be a few very base standard sort of terms. One is that variation orders to increase price of the contract will no longer require ministerial approval, so the government entity will have the freedom to work out how it actually goes about issuing variations until such a point as that 10% cap is reached. Certainly something you should be aware of when pricing your contract, if your pricing will be subject to, or if you haven't received all of the documents, so you know that there's going to be a large portion of variations that might be issued throughout the project cycle. And if that those variations are likely to amount to more than 10% of the contract value, there's going to be some difficulty with getting those variations approved, because you will then be pushed into having to seek ministerial approval. Additionally, also be aware that given the ability to reduce works, there is no ministerial approval required to reduce those works by 20%. So again, this does present a risk. Performance bonds, I briefly touched on that they're going to be required to be provided within 15 days after the award, and this is actually to secure the award of that contract. If the performance bond isn't actually provided within those 15 days, there's the argument that could be raised that the award hasn't actually been confirmed. There's the ability to, where a bid bond has been provided, to convert that bid bond into a part of the performance bond, but certainly something you should be aware of in terms of getting your financing ready should you be awarded the project. Finally, the old government tenders and procurement law included decennial liability at Article 76. The new government tenders and procurement law no longer includes decennial liability, but it could be included in the implementing regulations, which are yet to be released. Decennial liability within KSA is an interesting position at the moment. So we're hearing that decennial liability will become mandatory. We haven't seen any regulations to this effect, but it's certainly something that you should be aware of, particularly in relation to a change of laws clause, which doesn't include a change in the requirement to obtain decennial liability insurance. As Saudi Arabia doesn't have a civil code which codifies the requirement to include decennial liability or any form of insurance in respect to decennial liability, certainly have some considerations to how you approach that. We've provided advice to a few of our clients in respect to this moving forward, but it's definitely something that you should keep your eyes peeled for new regulations which are released. One of the other large changes in respect to the government tenders and procurement law is the arbitration, the approval for arbitration to be used as the dispute resolution mechanism in government contracts. There are two large considerations here. One is that ministerial approval will be required. Two is that the contract value is to be over 100 million Saudi riyals, which is roughly 26 million US dollars, although this may be adjusted subject to approval by the minister. And finally, the Saudi Centre for Commercial Arbitration will be the institution to be used, and its rules will be applicable. Just touching quickly, there's been a ban on foreign consultancies, which was issued late last year. The ban seeks to limit the award of contracts to foreign consultancy advisory companies where a Saudi firm or research centre is able to provide the required consultancy services. There's been some confusion as to the intention of this law. There's been no regulations issued which provide some clarification as to how this law or this royal order will actually be implemented. It also provides no clarification as to what a foreign consultancy might be. So at the moment, it only distinguishes between foreign and national. In our view, the intention of this ban is to apply to financial services providers, and it's unlikely to apply to engineering or construction consultancies, but certainly something to be aware of. In terms of our construction and engineering consultancy clients, we haven't heard any issue in terms of them being awarded work. But one thing to consider is how any potential ban on any foreign financial services company might impact the financing of some of these mega projects. While there is the sort of loophole of not having a Saudi firm or research centre with sufficient experience to be able to offer the services, and thereby the award of the consultancy might be directed to a foreign consultancy advisory company, we don't think that there's going to be many Saudi firms or research centres with the capability to manage some of these projects. So certainly something to consider, but in our view, it's another way of directing money back into KSA organisations. So there's been the localisation push, there's been the push for local content, upskilling of locals, as well as a pushback of money into the KSA economy. So finally, just wrapping up in terms of contracting with the government. So a couple of key takeaways. The Kingdom is moving toward a more centralised procurement system, in which contractors will be expected to catalogue their levels of local content engagement and to increase their reliance on local content providers over time. Foreign companies that act proactively to comply with these changes will be best placed for future contracts. We expect the personal sales level relationships with government entities, which traditionally have been really important for winning business, to gradually diminish as the influence of the central oversight of the contracting process takes hold. However, it's very important to maintain those close relationships that you have with those government entities. Finally, it's going to take some time for the new systems, these online portals and the regulations to get up and running. It's also likely to take some time as officials at those new government offices become familiar with their roles. We also expect the laws may be amended and refined in the coming months to provide more clarity and precision around the implementation of these new laws. So in the short term, while you should expect some uncertainty, there's probably going to be limited changes to the bidding process and how you go about actually bidding for work. So we will keep you updated as and when those implementing regulations are released and provide our thoughts and commentary on how best to structure your tenders and structure your business in order that you are best placed to win work in the future. So I'll hand back to Scott now.
Thank you for that overview, Jeremy. I'm going to talk through some issues about private sector contracting. When I'm talking about private sector contracting, I'm talking about all non-direct government contracts. So it includes subcontracts, sub-consultancy agreements on government projects. What Jeremy was talking about was only when a party was directly contracting with a government entity, which is under the GTPL. So in the private sector, you may find that sometimes the contracting is unsophisticated. Just recently, we encountered a situation with a consultancy agreement where the terms that were being put forward were essentially a construction contract, and there was an obligation upon the design consultant to obtain marine hull insurance in respect to the services to be performed. So the misuse of standard form contracts appears to be an issue that needs to you need to be alert to make sure that you're not stuck with obligations that are irrelevant or difficult to comply with. Reason for this is that there is no construction law in Saudi Arabia, unlike the rest of the GCC, where there are civil codes or other jurisdictions where there are specialist construction laws. In Saudi Arabia, the starting point is your contract is your law. It's subject to Sharia. There is no civil code. So that will bring in concepts also of good faith, which will permeate throughout the contracting process, from entering into, performing or terminating the contract, as well as other Sharia concepts such as unjust enrichment. So, as I mentioned, the starting point is your contract is your law subject to Sharia, and this is where KSA law is the law of the contract. With government contracting, Jeremy's mentioned about the government having their own form of contract in the private sector. However, the most common contract you will encounter will be fitting or fitting-based contract, generally 1987 or 99, Red Book versions that you'll encounter, as well as the EPC Silver Book. Jeremy mentioned about the government contracts. It will impact the private sector contracting because contract provisions often flow through in a project. So there's often difficulty in negotiating terms on government contracts. It's fairly limited to really scope of works, materials to be used, and maybe the rate of delayed damages. Delayed damages generally are recoverable or recognised under Sharia, provided that they reflect the direct and demonstrable losses that will likely be suffered. that are suffered. You do have unlimited liability that you need to be aware of in KSA. There's no limitation period, statutory limitation period on bringing in action, so a good claim never dies is something that will apply in Saudi Arabia. However, it may be possible to, by contract, seek to limit your liability subject to unjust enrichment and the ability of it being overturned should it not reflect direct and demonstrable losses. But where it is a reasonable provision and the parties have agreed, the courts may be inclined to uphold it given that the contract is dual law to start with. Also be aware of resourcing requirements often in government projects that will be passed through, such as the requirement to use Saudi air to transfer workers, move workers, to transit goods through Saudi rail operators. These are things that have to be factored in for costs. Another concern is often the boycott of Israel clauses or obligation to comply with all laws, particularly where you have US entities. An obligation to comply with the laws can be problematic as it may contravene for a US entity the US Export Administration Act or Internal Revenue Service rules. How we get around that is that rather than having to comply with the laws, if you seek to try to amend it so that those laws shall apply, then that passive language, according to the EEA and their guidance, is sufficient in that you're giving recognition that the laws do apply, but that you're not actually actively participating in the enforcement or participation of those laws. If you're unable to agree that change, alternatively, you may be able to have a provision added into the contract similar to something like except to the extent compliance is inconsistent with or could subject the consultant or subcontractor to penalties or fines under the laws of the United States. There's other things to think about as well, such as variation clauses. Variation provisions are common. It's often found in contracts in KSA that there may be a limit on variations to 10% of the contract value. So, for example, if you do have a design and build and you take on some design risk, and because of variations that occur in that design process, you may find that you have an inability to recover beyond 10% of the contract price for design changes, because the courts will hold initially that your contract is your law, even though there was incomplete design, and that you may inadvertently take on that design risk. Another thing to think about is the back-to-back contract obligations where the main contract is not provided. One of my first cases in Saudi Arabia involved a subcontract situation on a government project, and there are the usual provisions that the main contract applies, and that they negotiated in the subcontractor the right to suspend when there was non-payment. But there was also a provision in the subcontract that to the extent of any inconsistency between the subcontract and the main contract prevails and the subcontractor shall not place the main contractor in breach of the main contract. Unfortunately, the main contract had no right to suspend, and the subcontractor was not paid. And that led to a very difficult argument as to what were the exact provisions of that particular subcontract and how it was to apply. Termination provisions by agreement are generally permitted as well. Be wary of force majeure. You may wish to ensure that your contract has a broader force majeure provision, particularly in light of what is currently happening. Under the Saudi law, if there is no contractual force majeure provision. Force majeure will only apply in the case of absolute impossibility, which is a lot narrower than what would generally be considered a force majeure situation under most contracts or fitting standard form contracts. So what we also find is that there is no decennial liability in Saudi Arabia, not in the sense of what's in civil codes, but we do see civil decennial liability included by way of contract, and you need to be wary of the clauses where decennial obligations seem to be extended. Some clauses that we've come across extended to any materials or methods which may reasonably be suspected to be unstable, dangerous, combustible, otherwise unsuitable or inadequate. Materials generally known to be deleterious at the time for completion, which are deleterious to health and safety or durability. So you need to be aware of those type of provisions, particularly as to whether they are insurable or not. Make sure you check with the insurance coverage beforehand. There has been some discussion about mandating decennial insurance on government projects, but that's no longer required. It may be possible for the private sector, but that discussion hasn't progressed recently, particularly as it may be difficult to obtain in the market. Jeremy mentioned earlier about withholding tax. I'm not a tax expert, but I'll just cover off generally some of the withholding tax issues that you should be aware of. Payments made from a resident party to a non-resident party for services performed are subject to withholding tax, and the rates vary between 5%, 15% and 20% based on the type of services and whether the beneficiary is a related party. The withholding tax should be paid within the first 10 days of the month following the month during which the payment was made. Typically, we understand that where a company has set up a joint venture or association agreement with a local contractor, the rate of withholding tax payable on money sent to the non-resident company will be 15%. What we have seen with some of our clients is to minimise the exposure to withholding tax is by having their KSA entity, that's a joint venture association, sign the contract, but providing the services out of their overseas offices, relying upon double taxation treaties set up between Saudi Arabia and the country in which the service is being provided. Next, I just want to touch on briefly arbitration. Arbitration is government projects. Jeremy has already covered. Just briefly, it has to be over Saudi 100 million riyals, ministerial approval required, and generally it will be at the Saudi Centre for Commercial Arbitration or Licensed Arbitration Centre. We're not sure of any other licensed arbitration centres that will be the arbitral institution. In the private sector, generally you're free to agree on to have arbitration in the private sector. So it's quite common for parties doing business in KSA to select binding arbitration in the kingdom, or they may have external arbitration in an international venue. It's noteworthy that Saudi Arabia is a signatory to the New York Convention since 1994. For domestic arbitration, there is an arbitration law that was enacted in 2012 which confirms the right of parties to agree to settle their disputes for arbitration. And this arbitration law is based on the Untitled Model Law, so it embraces international standards and aligns Saudi Arabia with other arbitration regimes within the Middle East. So there's independence of the arbitral process and enhanced procedural powers for arbitral tribunal. The law clarifies the process surrounding the enforcement of arbitration agreements and awards. One point to be wary of is that, however, if there is a point of Sharia law that you may be subject to dual proceedings, and that it may still be possible to bring the point of Sharia law for decision before the Saudi courts or board of grievance, notwithstanding the arbitration agreement. Coming to enforcement, which is also important, particularly with foreign awards and where the assets are located within the Kingdom of Saudi Arabia. There is an enforcement law which came into effect, and it is improved procedures within Saudi Arabia from what was previously the case. Previously, before this law came into effect, to enforce an award and application first had to be made to the Administrative Judicial Committee responsible for administrating arbitration, that being the Saudi Board of Grievances. And the Board of Grievances would often undertake an intense review of awards and scrutinise whether an award was compliant with the laws of Islamic Sharia, which commonly resulted in awards being annulled or amended. Our understanding is that from the commencement of the new law in March 2013, the enforcement application is heard before one execution judge, and the cumbersome procedure through the Board of Grievances no longer applies, and there is a substantially reduced risk of the invasive provision of arbitral awards, and that awards are much more enforceable. International awards are much more enforceable within KSA. The issues, for example, of having a woman arbitrator make the decision is no longer an issue. I understand that was an issue some years back. I understand there was an ICC award made by a female arbitrator, and that was enforced in KSA. So enforcement within KSA is certainly something that is substantially easier than what it previously was the case. So in conclusion, we have Saudi with Vision 2030. I think it's now Vision 2035, recently been updated, where they're looking to open up areas and expand their non-oil sector, particularly in the tourism market. And with many projects going on, they've got the new government tenders and procurement law to try and assist with obtaining better outcomes for the contracting process, with standard government contract terms coming into new standard government contract terms coming into effect. We also have things that you have to be aware of, though, if you're in the private sector, which I've touched on, and an increased ability for arbitration within Saudi Arabia rather than being before the local board of grievances. Do you have any questions for us? If not, you can just leave some questions, and this will be the end of the webinar for today. I thank you very much for attending. If you do send any questions, we will try to answer them for you. Thank you very much, and I hope you've enjoyed the webinar.